Major breaking news, the United States Supreme Court held an oral argument today in the VanDerStok versus Merrick Garland case, which involves a challenge to the ATF's expansion of what constitutes a firearm under the Gun Control Act of 1968. A big fight today. The ATF and the Department of Justice brought out their big guns, the Solicitor General herself. Let's break it all down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarm, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. All right, we're going to get right to it, folks. Long oral argument today, about an hour and a half or so before the United States Supreme Court. A big fight over whether or not the ATF had exceeded its authority under the Gun Control Act of 1968 by expanding the definition of what is a firearm. Just to jog your memory, under the federal statute, a firearm is a weapon that is designed to or can be readily converted, and this is the key language, can be readily converted to fire a projectile by virtue of an explosion or the frame or receiver of any such weapon. What the ATF did under Joe Biden and Kamala Harris is they expanded the definition of firearm by saying that anything that could become a frame or receiver or could readily be converted to a frame or receiver is a frame or receiver, and therefore weapon parts kits or partially completed frames and receivers were somehow firearms that required people, if you're going to sell those in business, to get a federal firearms license, and if you're going to buy one, to go through a NICS background check. So this is a big fight. We talked about the text here, and I explained to you in my prior video about what to look for is if the Supreme Court is laser focused on the text of the Gun Control Act, that's good for us. If they're talking about public policy considerations, that's bad for us. So let me just cut to the chase. I think this is going to be a very close case. I think this is probably going to be a 5-4 decision. I think we will lose for sure the three liberals, including Justice Brown Jackson, Justice Kagan, Justice Sotomayor, and I think we will also lose the Deep State Chief Justice John Roberts to the left. The question will then become is how many votes can we get on the other side, meaning the other 5 conservative votes, if you want to call them conservatives or originalists, whatever you want to construe them to be, the 5 so-called conservative justices, can you get all 5? I think we will get Justice Gorsuch, I think Thomas and Alito, and I think Kavanaugh and Barrett look favorable, although no guarantee. As you know, it is very difficult to understand and know what's really going on during oral argument because they're often asking questions and prodding and pushing people to understand the scope of what may ultimately be their decision. Because keep in mind that the only information available to the Supreme Court justices it's not just the oral argument, but the dozens of briefs and arguments and memos and whatnot that their law clerks have prepared. So there's a lot of information. So the purpose of the oral argument is often to focus in on very specific issues that they want to reflect on. Now, this is the key point. Where this is going to come down, I suspect, is where does Justice Kavanaugh and Justice Barrett come out? So let's see what they did today. So Justice Barrett specifically asked some critical questions about weapon parts kits, and she used kind of the metaphor, this was going back and forth a little bit, about an omelet. Specifically, she picked up on Justice Alito's question to the government that went along the following lines. If I buy eggs and vegetables and other items, and I place it on my kitchen counter, is that an omelet? Well, obviously it's not an omelet yet. Those are the ingredients that go into an omelet. And then, of course, the question becomes, if you have the exact same items on that kitchen table, but you remove the eggs, meaning you have everything but the eggs, then do you have an omelet? The answer is unlikely no. And why do we say that? Because a critical component of an omelet is the eggs. By metaphor, a critical component of a firearm is the frame or receiver, which is why the definition of what is a frame or receiver is the single most important 1,000% critical question that is being answered and will have to be addressed by the Supreme Court in this case. What is a frame or receiver? The reason why I say this, and it's pretty clear from the Supreme Court argument today based on the questions of Barrett, Kavanaugh, and the others, that if a frame or receiver is included in a weapons parts kit, for example, it is a firearm, which we've talked about in the past. And here's the thing, Justice Kavanaugh was very concerned about this apparent expansion of the definition of frame or receiver because he was worried about what this would mean for the rest of the Gun Control Act and all of federal gun control laws. Because it's pretty clear that if you expand the definition of firearm in this one particular section as to what is a firearm, you don't just implicate the rules associated with background checks, NICS checks, and the like. You arguably influence the definition of firearm throughout all federal statutory law. So Justice Kavanaugh was clearly concerned about this implication because he was asking a series of questions about mens rea or scienter, which is the criminal intent in a criminal statute. And, could somebody fall into this trap if they don't know better? And there was a lot of back and forth between Justice Kavanaugh and the Department of Justice about whether or not somebody could be ensnared in committing a federal crime because they don't know they actually possess a firearm. So that's quite interesting that Justice Kavanaugh has real concerns there, and I think that's a favorable sign. Now, Justice Barrett raised a couple interesting questions, and this is most important, and then we're going to tie this together where I think the court may go. And I will tell you this is going to be a close case. Every one of these cases involving firearms technology are close cases because I don't think the justices fully understand firearms technology. That's why I thought the Cargill case could go 50-50 involving bump stocks, not because I didn't think we had the better argument, but because I thought the Supreme Court might not really understand the technology. So here we're doing the same thing again as to whether or not will this court understand frames and receivers and what are partially completed frames and receivers and weapons parts kits. Because if they mess up the technology or they mess up kind of these items, there's a great chance that they will get this decision wrong. But we will see. I take some hope in the following sort of back and forth between the lawyer for Jennifer VanDerStok on the one hand and Justice Barrett on the other hand. And this was a discussion involving a lower court decision by United States Court of Appeals Judge Andrew Oldham. This is a big deal because Judge Oldham said in the Fifth Circuit in ruling in favor of the VanDerStok plaintiffs against the ATFs, he said, look, if your position, ATF, is correct, which is that an item that is not yet a frame or receiver, but can become a frame or receiver by the drilling of a single hole into that item, and then it officially becomes a functional frame or receiver, then that would have dramatic criminal consequences for owners of AR-15s. And this was discussed several times during the argument. And you're like, how does all this connect up? And here's how it connects up. Remember I explained to you that the statute talks about a weapon that is readily convertible to shoot a projectile by virtue of an explosion, readily convertible. That appears in Section A of the statute. But the readily convertible language does not appear in Section B of the statute. Section B of the statute that we're talking about in this case today refers to frame or receiver. It doesn't say frame or receiver or something that can be readily converted into a frame or receiver. So there's a lot of back and forth today about whether or not if an item just required the drilling of a single hole, then is that still a frame or receiver? Well, if the answer is yes, that's a frame or receiver, and if the item only requires the drilling of a single hole, and then it becomes a frame or receiver because it's readily converted, guess what that means for the AR-15 and machine gun issue? That would mean, and this is what Judge Oldham flagged and Justice Barrett was clearly concerned about in this argument today, that would mean that an AR-15 becomes a machine gun because an AR-15, by virtue of drilling a single hole, in theory could become a machine gun and thus could be readily convertible into a machine gun. And thus AR-15s, semi-automatic AR-15s, are machine guns by virtue of that logic. That clearly concerned Justice Barrett because she brought this up in the back and forth. So where I think we stand is Justice Alito and Justice Gorsuch asked a series of questions, as they should as judges, about the text of the statute. They really wanted to understand the textual arguments, although I think they're pretty clear. There weren't as many questions directed to the Department of Justice about the text, but that may be because it's obvious. There's no real answer. The text appears in Section A, readily convertible to fire a projectile, and not in B. It doesn't say readily convertible into a frame or receiver. And there was clearly discussion, even by some of the liberal justices, who I don't think we're going to win, about what constitutes readily convertible. And then here's the key, and if you want to get a little geeky here, the VanDerStok attorney took really two positions and said, first of all, they think the proper definition a framer receiver is a functional framer receiver, meaning something that actually works as a framer receiver. And that if it doesn't work as a framer receiver, it's not a framer receiver. And thus, you can sell it without a background check or without being NFL because it's not a framer receiver. And likewise, if you sell a weapon parts kit that does not have a framer receiver, it by definition is not a firearm because it's just parts. The only way a weapons parts kit becomes a firearm is if it includes a framer receiver, which is why the definition of what is a framer receiver, with or without additional milling or machining, is mission critical and will decide all aspects of this case as I see it. Now, with that said, what the VanDerStok attorney said is the first position, the proper position, is that if it's a fully functional receiver or frame, then it's frame or receiver. But then they went on to say that for the sake of sort of argument, as an alternative argument, they say the proper interpretation of frame or receiver could be what the language meant when it was adopted at the time of the statute in 1968. And at the time the Gun Control Act of 1968 was adopted, defining firearm to include a frame or receiver. A frame or receiver was understood to be the holding, the item that holds the parts of the gun together. It wasn't what the ATF defines a frame or receiver today in the year of our Lord, 2024, which they include the item plus a jig or template, meaning to define what is a frame or receiver in the year of our Lord 2024, the ATF doesn't use the same approach that they used in 1968 and they used for 50 years thereafter. Instead, they say, what else is the alleged frame or receiver sold with? And then they analyze it that way. And because if it's sold with a jig or a template, then they view that as a frame or receiver. But that's kind of absurd. That's like just saying if it's being sold with instructions, but that's the DOJ ATF position. So really the alternative position of the VanDerStok attorney was if they don't buy into the functional frame or receiver as what is a frame or receiver, then you look at what's known as has there been a sufficient amount of critical milling or critical manufacturing associated with this item so that really the only thing left to be done is to maybe remove the packing tape and things like that, and then it would function as a frame or receiver, some protective device or something like that that might protect it. So basically they're arguing in the alternative that the ATF could, in theory, go back to what they did for 5 decades before the Biden-Harris administration, and everything they've done post-Biden-Harris administration is a violation of the statute. Again, only time will tell what the court does. So I'm going to break this down in greater detail in future videos. I'll try to place some of the transcripts for you. This is a very technical case, the same way bump stock was. A lot of people are going to tell you that they thought that the Department of Justice seems like they're going to win this case. They may win this case. It's true, but there's a lot of arguments that the Supreme Court's going to have to get around to rule in favor of the Department of Justice. And again, I think this is going to be a 5-4 decision. If it comes out in favor of our view, it will be 5-4 in our favor. And if it doesn't, it's possible that Kavanaugh and Barrett could rule in favor of the Department of Justice. That is certainly possible. They definitely asked a lot of serious questions, and I can tell they're taking this case seriously. And there's a lot for them to consider here. Now, we should win this case. As to whether or not we will, I cannot predict, but I still am cautiously optimistic, but only time will tell. We will know this probably sometime in the spring of 2025. All right, folks, hope you learned something here today. We'll keep you apprised as developments occur in this case and others before the U.S. Supreme Court, and we will see you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.